history of the property shows that in 1988, the county had stabilized any flooding that had previously occurred on the property, and from 1988 to 1995, no water flowed on the property. So again, the owner bought the property in 1992 in the middle of that time period. In 1995, Hurricane Opal occurred, and the county reconfigured the drainage in this area in order to alleviate flooding that was occurring on other properties. The county flooded this owner's property, and the county did that under an emergency statute that authorized that action. In 1990, from 1996 to 1999, the county and the owner tried to work together to fix the problem caused by this flooding that occurred in 1995, and those efforts were unsuccessful from 1996 to 1999. In 2005, those conditions remained, and the owner finally sued the county for two inverse condemnation claims, one for a period between 1996 and 2004, and then the second for a period from 2005 on. The critical fact, according to this decision, was that in 1988, the ditch had stabilized, and there was a ditch to drain the property, drain water on the property, had stabilized, and there was no longer any flooding on the property. The county argued, well, look, we're just doing what we're authorized by statute. We're not guilty of any kind of taking here. And beside the fact, prior to 1998, you had water discharge on here for centuries. The court said that because the appellate court said that because this water drainage had stabilized prior to the owner purchasing the property, that the owner could reasonably rely on that drainage stabilization when they purchased it. Even though the statute authorized the county to construct a ditch, in this case, the ditch stayed more than just those emergency situations, and that a taking occurs when the government action constitutes a substantial interference with those private property rights for more than a momentary period, more than an emergency period, and will be continuous or reasonably expected to continuously recur, resulting in deprivation of use of the property. The court went on to say that taking as a matter of law occurs where the county diverts water across the owner's property and continues that diversion after the emergency passes. Again, the court went on to say that even though the statute authorized emergency actions to excavate drainage paths to preserve property, it doesn't prevent you from making a claim for a taking. In other words, Article 10, Section 6 of the Florida Constitution still allows for compensation even for statutorily authorized actions of government entity. The court said that the trial court erred by entering judgment against the owner and ruling that the diversion of water did not constitute a taking because the diversion, even though the diversion was due to a declared emergency. The next case we have is New Testament Baptist Church, Inc. of Miami versus State Department of Transportation. This is a case where I have to disclose that I was trial and appellate counsel for the property owner. We represented New Testament Baptist Church of Florida, which operated a private school on some church property on Griffin Road down in Fort Lauderdale. And prior to the church coming to us as clients in 1990, they sought to have the property platted to allow them to put a private school and a church on the 100 acres of property. In order to do that, Broward County required the church to dedicate 7.5 acres of property along Griffin Road for future right-of-way uses. The church provided that dedication by plat in 1990 and subsequently developed the property for its private school. The church continued to maintain the platted area, the 7.5 acres, put fences on it, and other improvements on it, and mowed it and took care of it. The county asserted no use over that property for that entire time period until 2005. In 2005, Broward County entered into a joint participation agreement with the Department of Transportation for the widening of Griffin Road, and then DOT sought to condemn property for the widening of Griffin Road, which included them using a portion of the 7.5 acres that was previously dedicated to the county. As a part of that eminent domain action, the owners claimed that they were entitled to compensation for that property that's being used by DOT that was previously dedicated to the county by plat. The owners argued that the plat dedication was void, for instance, inception because it violated Dolan and Nolan. Essentially, there was no essential nexus between the required dedication of 7.5 acres and the use that the owners were going to make of their property for a private school, and then secondly, there was no proportionality. There was no rough proportionality between the total extent of that dedication, 7.5 acres, and any traffic counts that might be generated by having a private school operating. So the owners argued that it was void from its inception. It conveyed nothing back in 1990, so we retained ownership of it, and we continued to assert control over it and use it. And it wasn't until 15 years later that the county finally decided, well, we want this property. The appellate court, the trial court granted summary judgment in favor of the Department of Transportation and Broward County, and the appellate court affirmed. The court again confirms that we have a 4-year statute of limitations that applies to inverse condemnation claims. The court said that a plat dedication that was a condition for application approval was not void from its inception, but merely voidable. In other words, if it was void from its inception, it would be dead on arrival. If it was merely voidable, you would have to bring a lawsuit or get some kind of declaration that that government exaction was not effective. The court said that it was merely voidable where it only affected the applicant and not the general public, and that the statute of limitations applied to that plat dedication where the rights of third parties were not affected, and again affirmed the trial court. The interesting part of that is that in order to do that, the 4th District Court of Appeal did not cite any Florida case to decide that it was merely voidable as opposed to void. They rejected a series of Florida Supreme Court cases that said that constitutionally void conveyances are void ab initio as opposed to merely voidable. And they cited a decision from the Supreme Court of Utah as authority to say that where the rights of third parties are not affected, that the action is merely voidable. So we sought jurisdiction to the Florida Supreme Court, and the Florida Supreme Court, and it was discretionary jurisdiction, and the Florida Supreme Court said, well, we're not going to exercise discretion here. We're not going to take the case. So the court never said that we shouldn't take the case. It said we're not going to take the case. What's nice about this is we will get some, and the Florida Supreme Court has never addressed Dolan and Nolan, which are the exaction cases out of the United States Supreme Court, and it will do so in a case I'm going to talk about here in just a minute. So that was New Testament. The next is Crowley Museum and Nature Center versus Southwest Florida Water Management District. In this case, there was downstream flooding that occurred to an owner's property, and as a result of that downstream flooding, the owners claimed that